So interested to hear about the law reform process in particular and how the position paper has been produced and how you got to that point, but to describe in more detail some of the plans for this law reform. So thank you for that.
Yeah, no problem. Look, you've obviously had, I think, a very good presentation from Kevin on both the premise of the minimum age of criminal responsibility law reform and some of the issues in the ACT. Let me take a step back as to why we're doing it. The ACT government has clearly adopted, in my time in responsibility for this portfolio area, a policy of justice reinvestment. Yeah, I'm sure you've all come across this, but at its most simple, the idea that we want to spend our money at the front of the system rather than at the end of the system. We want to spend our money on preventative measures that minimise people's contact with the criminal justice system rather than spending our money on building bigger, ever bigger jails. Across Australia, we've seen over the last couple of decades, you cannot build enough jails. They simply keep filling. And the prison population in Australia has escalated significantly in the last few decades, and particularly disproportionately contains Aboriginal and Torres Strait Islander people. These are all reasons why we need to adopt, in my view, a justice reinvestment approach to criminal justice policy, particularly in Australia. In that context, raising the minimum age of criminal responsibility is exactly that. As Kevin talked about in his presentation, not only is it a law reform, but also we need to invest in a series of service responses that will provide the right support mechanisms to ensure that young people get their lives back on track and get their supports, the supports they need, so they're not engaging in harmful behaviours, whether those behaviours are harmful to them or harmful to others. So I think for me, that's a really important framing of why raising the minimum age of criminal responsibility is such an important reform and why we've certainly invested so much effort into it. The brief history in the ACT is that this issue was being discussed by Attorneys General, well, through sort of 2018 to 2020. I was not the attorney at the time. I was the Justice Minister in the ACT government, a slightly different portfolio. But as a Greens parliamentarian, so also with a sort of non-executive role, I moved a motion in the Assembly calling for the age of criminal responsibility to be raised. It was supported. We then had an election campaign and I became the attorney, and so we've moved forward with implementing this. We've done a lot of consultation in the last couple of years, and it's taken us more time to get through this than I would have hoped. The key reason for that is the actual legal reform around raising the age of criminal responsibility is reasonably straightforward. The legislative drafting is not overly complicated, but building the service system that supports young people takes a lot more effort. And so that's where we have probably spent more of our time in thinking about that. As Kevin touched on, I think internationally it's recognised that Australia's minimum age of criminal responsibility is well below international standards. The international average is around 14.5 years of age. In Australia at the moment, everywhere except the Northern Territory, it's 10. The Northern Territory, of course, has just gone to 12. Here in the ACT, we have committed to raise the age to 14, and we're certainly well on track to do that. I think that the first thing we did was commission a report by Morag MacArthur, who's a professor at ANU. That review was a review of the service system and implementation requirements for raising the minimum age of criminal responsibility. That was a very detailed report which has provided extensive recommendations in that support space. And so if that's an area of interest for you, that report is publicly available and has quite detailed discussion of both the current situation and the situation we would want to get to in the ACT. One of the key questions then is, what should the age be raised to? My view very clearly, and the view of many of the advocates in Australia, Change the Record, a whole range, Amnesty International and others, is that it should be raised to 14. Through a range of discussions, we have ultimately decided it will be raised to 14 in the ACT. We intend to do that in a stepped way. We have roughly 40 to 50 young people a year who would come into contact with the criminal justice system in the Territory. Of that, only a handful would be aged 10 and 11. and the rest would be aged 12 and 13. So our intent is to draft the bill. The age will raise immediately to 12 on passage of the bill. We believe we have the service system and the capability in place for that small handful of young people. And then the legislation will contain a provision that raises the age again within, at the most, 2 years later, potentially sooner, if we're ready to go. And that gives us a period to increase our service capacity over time. And so I think it's really important to understand, we've had some critique in announcing that, but we are raising the age to 14. It will all be in one piece of legislation, but it will have, I guess, different commencement dates for the different ages. So that is the approach we've decided to take. And I think that it gives us the opportunity to really ensure that we have the service system in place so that when those ages do change, we have the right supports. One of the issues that flows from that is what powers will police continue to have? And we are taking an approach that police will retain the powers they have at the moment for dealing with children under 10. And so those same powers will continue to apply as the age of criminal responsibility rises to those young people. And so that includes the power to arrest a child with or without a warrant in certain circumstances. What that's designed to do is ensure that police as first responders can continue to provide public safety where a young person is engaging in harmful behaviour, harmful to them or somebody else. So, frankly, at 1 o'clock in the morning, the police can pick a young person up. It's the consequence of what happens then. Rather than going to the criminal justice system, they'll be diverted into a service response. And that's obviously a really important difference that ensures a degree of, ensures community safety, but makes sure that once a young person's in the system, they go on a different pathway. One of the issues touched on in the last presentation is the question of exceptions. This is a very difficult question, as you saw, it's very contested. The Cabinet has taken an in-principle decision that there will be exceptions for children aged 12 and 13. So not those under 12, but for a limited set of circumstances, which would include, it's the definition of it is still being worked on, but it'll be those most serious offences, so murder and serious sexual offences involving violence. This is a really contested view, even within the Cabinet. I think it's fair to reflect that my party, the Greens, do not support exceptions, but a number of our Labor colleagues want to have exceptions, and so it is a political discussion that is taking place in our Cabinet. And we have an unusual situation here in the ACT where we have a combined Labor-Greens government, and so this is an example where at times our two parties have to really work through these issues, and we'll have to resolve this once and for all before the legislation is introduced. We expect to have the legislation in the Parliament in the first quarter of this year, so these issues are going to be resolved in the next few weeks. So as I'm talking to you today, this really is a live question here at the moment. Look, let me touch on the last few things about the features of the legislation, and then I can sort of stop and go to any questions. I've talked a lot about the service response. Some of this will be reflected in the legislation. That will include things. So there's sort of the straight service responses, which are a resource question and don't require legislation. And these are things like increasing access to family-led decision-making mechanisms, such as family group conferencing. It's a mechanism we're already using here, but we'll expand the capability of it and enable more people to be eligible. We'll enable more intensive and more earlier intervention with young people by tweaking the service response and changing criteria for access to services. But then we are also intending under legislation to establish a therapeutic panel, which is basically a group of experts. When a young person is identified as being involved in those harmful behaviours, they'll go before the therapeutic panel who will examine their circumstances and identify what are the best therapeutic responses to support that young person. And that could be everything from alcohol and drug treatment services to mental health support to a range of other interventions that go to the drivers for that young person's behaviour. We'll also develop a new, what's been called an intensive therapeutic order. Now, this will be a civil order, not a criminal order, but it will allow the courts, allow the Children's Court to put in place orders that require a young person to reside at a therapeutic residential facility for a limited period, for example, and other mandated requirements. I guess this is in recognition that we will have some young people who will not respond entirely to voluntary treatment, and there will need to be the potential for mandated treatment. It's very similar to, I have earlier brought through an adult response. It's very similar. It's called an intensive corrections order. And again, means a person can serve in the adult case, their sentence in the community, but subject to certain conditions. So it's very much premised on the same idea. Perhaps the last couple of comments I can make is there are a series of legal issues that need to be worked through, things such as how do we deal with spent convictions, both for those that have had a conviction in the past and also during the transition period. Those sort of legal issues are not controversial, but are the details that are required. Ultimately, this bill in its current form is over 150 pages. So there's a lot of detail to work through there, but many of those legal things are more practical rather than significant law reform issues, but they are consequential to what we're trying to do. So that is a crash course in the reform we're doing. I'd rather stop and invite questions and just talk at you the whole time. So, Mark, I'll hand back to you in the first instance, I guess.
Thanks so much, and wonderful amount of time for questions. So we have a good 20 minutes for questions. One question comes from one of our staff members, Hayley McEwen, up on Biripi land in Port Macquarie, and she's asking, is there an element of rural proofing taking place to ensure that young people disadvantaged by distance in rural, regional, remote areas will have real access to the therapeutic alternatives proposed? Being the ACT a different challenge, I suppose, than a geographical area as vast as New South Wales, South Australia, Ashram, or other states and territories that might respond as you have been doing in the ACT. But do you care to comment on those types of matters and just disadvantage of people accessing the therapeutic panel, etc., in the ACT?
Yeah, look, it's a really good question. As you touch on, Mark, not relevant to us because being a city state, we don't have those geographic spreads. I think if you were to do this reform in other places, it is a really valid question. We sort of have, that said, we have a not dissimilar problem to some of the more rural areas in that we have small numbers. And so in trying to think about questions, for example, of, we have a youth detention centre at the moment. It's like a jail, but for young people. And, we like to think that it's reasonably therapeutic. But if we take that option away of sending young people to the Youth Justice Centre, but they continue to offend, where we need to put them at a residential, require them to be at a place of residence, for example, there's a risk that we actually make their situation worse because they might be by themselves. In the Youth Justice Centre, there'll be other young people there. And if we isolate somebody because we only have one or two at a time, that sort of becomes an issue as well. We struggle with having enough people sometimes to put courses and programs together. So these, I think, are similar issues to rural areas in just that you don't have the scale, that it becomes very expensive to do these things otherwise.
Thank you. And Bri, you have your hand up, so please unmute and ask a question to the Minister. Thanks.
Thank you. I'm a first year law student, but also a mother of two. And I just wanted to know, in implementing this, what are you doing in relation to services for children before the offence? So I know with my children, it's very hard in the current environment in the healthcare system to access services such as mental health services for challenging behaviours. Is there any scope within your new policies for easier access for families to these services before offending occurs?
Yeah, thanks, Brian. It goes to the heart of what we're trying to do here, which is to make sure we're investing the resources into those services at the beginning. Certainly the intent is to put the stronger service system in place and get the earlier identifications. So, young people will come to the attention of whether it's the police or various service systems, often long before there's an offence taking place. And so part of the beefing up of the service response is to make sure they get that early engagement with those services. So yes, basically we have to spend more money on those things. But the saving, clearly, if we do that well, the savings out the other end of the system will pay for that over time. From a government point of view, and particularly as an individual minister, the hardest part in the short term is convincing Treasury to put more money in, because the savings don't come for a while, but the investment costs a lot at the beginning. And so that's to be honest, the political challenge at the beginning of this process.
Thanks, Brian. Thanks, Minister.
Thank you.
Other questions can go in the chat, and I can direct them to the attorney when you've popped them in there. I'm bursting with questions, as you might suspect. Mainly because the last time I heard someone talking about some of these issues was at a psychiatry, psychology and law conference, where historically the focus has been on the Dolly Incapax defence and how that helps young people. As I sense this, it could mean the death of the Dolly Incapax history of rules in Australia and some Australian jurisdictions. It'd be interesting to see what happens in coalition with this debate around exceptions. But it seems to be a paradigm shift, doesn't it? We're moving away from the Dolly Incapax defence and the way it would actually work to a different regime of exceptions to the minimum age of criminal responsibility. So I wanted to ask you about that. I know there have been some controversial cases about the interpretation of the Commonwealth Criminal Code, Williams and M, for example, where some lawyers would say that Dolly Incapax codified is working differently in the ACT than other jurisdictions. But it just seems to be a moment in which we move away from that whole history in criminal law of common law and then statutory Dolly Incapax defences. Is that how you see it in terms of the choices Attorney Generals and governments have to make about how the minimum age of criminal responsibility is going to then clean up that area of Dolly Incapax law or abolish it altogether?
Yeah, I think you're right, Mark, in the sense that the premise of raising the age of criminal responsibility is an acceptance of the understood neurological evidence about people's ability to form an understanding of the consequences of their actions. And in some ways, and particularly I think the way you framed it, you could make the point that raising the age does codify that notion of Dolly Incapax in saying, well, it acknowledges an acceptance that at certain ages, young people can't make those decisions in an informed and sensible way.
And we should describe what that is first, I suppose. What has historically been the impact of Dolly Incapax on top of the minimum age of criminal responsibility being at 10? I'm happy to have a go as well as you, Minister.
I'll let you start, Mark, and I'll add any perspectives.
Okay. So a common law and then legislatively, between the ages of 10 and 14, there is a presumption that you don't have the capacity to form mens rea, as both Kevin has alluded to, and I think Asham as well. What would normally happen is that the prosecution would bear the onus of proof to prove that someone that they want to charge and prosecute for a serious or any offence actually has the capacity to form the mens rea. So you end up with these arguments between defence and prosecution lawyers about why we have indicators that a particular young person can form the mental element of an offence. And it used to be common law doctrine. It is now legislated, but what's not really legislated and is still common law is actually how you do that proof. And that's where the standout cases in the ACT, but other jurisdictions as well, that have gone up to the High Court about exactly why an individual is considered to have the capacity or not. As we change the minimum age of criminal responsibility from 10 to 12 to 14, hopefully in the ACT, that covers the entire period that was once captured by minimum age of criminal responsibility at 10, plus this argy-bargy between the prosecution and the defence about capacity. And that's refreshing in my mind. But the more that you inject exceptions into that regime, the more legally interesting it becomes. Is it going to be an exceptions argument triggered by our history of how we used to do it in Dolly Incapax cases, which is not perfect, as I think Kevin and others have said in submissions, if not today? And that's, hopefully that explains what dolly incapax has been. It's bad Latin again. It means incapacity to do mischief. Have I done a good job there, Minister, in trying to explain it? But
Yeah, it's why you're a law lecturer, Mark. I'm just the AG. Very nicely done.
So that's what it is, and that's where this exceptions argument is so crucial, isn't it? Do you feel that we could be reinventing the wheel of some quite controversial law around dolly incapax? And that's what your cabinet discussion is going to be about, I'd imagine.
Well, indeed, and Kevin's just made a good comment in the chat box. But if we have those exceptions, dolly incapax will have to remain for those matters, and so that you will not see the cleaning up as much as the general intent of raising the age is intended to. So there will be those complex cases where this issue will still arise. It's such a fascinating question. The politics of it goes like this. These are such rare cases. Everybody can talk about the Bolger case in the UK. And when you ask someone to name a case where there's been a murder by a young person, that's about the only one they can cite. There's a couple of others around the world, but they're so rare that everyone remembers them. And so the political discussion comes down to this question of we shouldn't have exceptions because if we accept the evidence that a child can't form that intent, then they can't form that intent no matter what the offence is. And so you should not have exceptions. That's the clear argument on that side of the equation. The political argument will be if they're so rare, they'll almost never get used, but they ensure a degree of community confidence in the law reform, is how the argument goes. But because it almost never happens, you'll never need them, so it doesn't matter to have them in the law. It's not a great argument, but that is the nature of politics, and that's the way that discussion's being had.
Thank you so much for that. I'm just popping a link to the Bolger case for people's understanding there. It led to the abolition of the dolly incapax defence in the UK in and around that controversy. Other questions, we're provoking you in many ways, I feel, and do feel comfortable, and thank you, Minister, for your time on a Saturday to be so open with fielding these questions from our students, a mixture of first-year law students through to people at all stages of their degree, and staff are on this call as well. So please feel free to use the time that we have for the next 9 minutes to raise some questions and voice some issues here. And we still have Kevin and Asham and our elders online here as well. So because we've been rushing earlier on, it's a good time to address questions to other speakers as well if you want to. As you're thinking, I'm going to inject a couple of other questions quickly to you, Minister. The law reform process from the Council of Australia, the Council of Attorneys General meetings in 2021 led to this parliamentary and governing agreement in the Assembly commitment. And then you had a discussion paper which invited submissions, and then a nice language, a listening report, where what you actually throw back to the community is all of the community members' perspectives on this issue, which is again in the link that I've shared with everyone. At the same time, the MacArthur independent review was going on, and then you have a discussion paper. Sometimes in the ACT, you have an exposure draft of controversial and large bills. You talked about a 150 or so page bill here. Is it? You may not have to answer this question at all, but that's another stage in the process. You don't have to tell me whether it's going to happen or not as an exposure draft, but I'm just trying to emphasize for everyone that lawyers are involved in all those steps, aren't they, in getting those processes to work, and your lawyers who work away on drafting bills as well as an exposure draft do important work. So an exposure draft is a draft of a bill that's put out for community consultation, not just the idea, but it's actually the detail of the bill, isn't it? That's how exposure drafts have worked in the ACT and other jurisdictions in the past. Do you care to comment on any of that? And just the role that exposure drafts or any stage of that process I've talked about is so important, and lawyers playing roles in those processes are so important.
I think what that emphasises is there's a lot of different ways to get community input. And as government, we use different strategies depending on who the stakeholders are and what the reform is. And so this bill has been particularly interesting because there's 3 ministers responsible for it. You know, as the attorney, I've got the primary carriage, but I've got the Minister for Youth Justice and the Minister for Young People, which are different portfolios, working with me as well. And so we've also got quite a diverse group of stakeholders, not just the lawyers, it's all these community service providers, the Youth Coalition and all sorts of others. On this one, as it happens, we're not going for a exposure draft, but there's a reason for that. The way we're going to operate is Cabinet will sign off on in principle on a version of the bill. We're then going to give it to some of our key stakeholders for a sort of more of a confidential opportunity to provide us some feedback on, are there any red flags in here of things we've missed? And we'll do that for a short period. And then our intent is to table the bill in the Assembly, but we now have a new process where all bills that are tabled in the Assembly can go to a committee. And so there's a Justice Committee, and that's made up of members of the Parliament who are not ministers. They will then have a public inquiry into that bill. And so we're using that public inquiry process as a step to really ventilate the bill publicly. We know it's going to happen. And so rather than doing exposure draft, then adjust it, table the bill and have a committee go over it, which becomes a very lengthy process. And, you know, the community, frankly, can get exhausted by too many levels, too many steps of consultation. We are taking a slightly different approach on this one. But it's always about trying to judge what's the best way to extract the feedback you need to get on these things.
And many steps in the law reform process can delay the ultimate law reform as well. I will just comment on the way. So good luck with all those processes. I'm happy for KD Co Global to unmute and ask your question that you've put in the chat to the Minister. Are you happy to do that? Yes.
Yeah, sure. Hey, Minister.
Good morning.
Good morning. My question was regarding, you did touch base on investing in preventative measures, such as like service responses, therapeutic services, and, you know, rather than taking children through a justice system, take them through a different pathway. And you talked about these justice youth service centers that are like jails. Is there any consideration into investing into these youth justice centers to reshape that environment for kids that actually cultivates these particular measures that you want to invest in?
I think the answer to the question is yes. In the broad, I mean, our youth justice centre is already designed to be as therapeutic as possible, in the sense that a young person who goes in the youth justice centre, they will attend school while they're there. They get access to all sorts of medical services, including particularly mental health and alcohol and drug services. You know, the centre's got a range of sporting activities. It's got its own swimming pool. There's all these kind of things. So it is designed to be a therapeutic environment, but ultimately it is still a criminal sanction. And so the nature of this reform is an endeavour to move away from that criminal context at all, and for young people to access those services in the community, potentially while they're still at home with their families, because again, often, not always, but often, it's best for them to be with their own family.
Right, yeah, absolutely. Yep, thanks. That answers the question. Thank you.
Cheers.
Thanks very much for your question, Sam. A few more moments left with the attorney if anyone's got some other questions you'd like to direct to the Minister right now.
I just have a question.
Thanks, Megan.
Megan. My background is medical, and it just made me think about the reforms in terms of the Richmond report and mental health, when they stopped they opened the doors of in inverted commas asylums. But we had problems with people in terms of the people who had been long-term. So they hadn't got those skills to cope outside of out of the institution. They'd been institutionalized. Sorry, I'd taken my thing off. So is there something that's sort of a part of this reform that helps the kids that are already in that sort of system because it's not just opening the doors and sort of letting people out doesn't help them because they haven't learned how to cope. So we have this revolving door of people in the mental health system who, and you see it when they're actually in the system because that's how they've learned to cope. They're in this place where they get their meals, they're accountable. You know, I can give you so many examples of people who, when they were in, you know, because this was the inner city of Sydney in Darlinghurst. So they walked past the pubs to go and get their cigarettes. But as soon as they weren't accountable and they were discharged and off onto their own thing, the first place they went was the pub. They would write themselves off, get arrested because they were drunk and disorderly, and end up back as an inpatient because that was the structure and that was how they learned because they'd been admitted for their mental health issues since they were teenagers. And now they're in their 40s and 50s and they don't know how to cook for themselves. They don't know how to, you know, those systems weren't there because we had reformed things. So it was sort of like you need to apply it to new diagnoses, but sort of the people that were there needed to stay because they'd spent their whole adult life in an institution. So is there a sort of a way that because the damage is sort of done because of old things.
Sorry. Yeah.
No, that's okay. I just does that make sense?
Absolutely. No, it's a really powerful point, Megan. For context, prior to becoming the attorney in 2020, the 8 years before that, I was the corrections minister, and I was also spent 4 years. We created a dedicated portfolio as mental health minister, and I had that as well. And the observation I'd make, going back to your starting point around the Richmond Review, is that yes, Australia deinstitutionalised its mental health facilities. My view is that a large number of those people have been reinstitutionalised within the corrections for exactly the reason you've pointed out to, which is that, yes, we threw open the doors, but we did not provide adequate investment in the support services. And those people, in various ways, I don't want to generalise, but in the broad, they have struggled to cope in mainstream society, many of them, and they end up in trouble. And because we don't have the mental health institutions necessarily anymore, they end up in jail. And I think that's a large part of the growth of Australia's prison population. That is a whole discussion in itself for the ones who've already been there. In terms of this particular reform, I guess the idea is in starting with young people right at the beginning, we are really seeking to make sure that they don't end up on that pathway that you've described. By getting to them when they're 10, 11, 12, 13, making those early investments at a critical juncture in their lives, we will avoid them ending up like that. Now, whether it's then they end up supported through the NDIS or through support, they actually go on to lead lives where they don't need support. You know, they're able to function.
So will there be allowances though for those who are already sort of, let's say the reform comes into play, and so it's okay for sort of the kids that are in that 10 to 14, but the ones that are already in that system who are still under, let's say 18, even though but so they've already kind of gotten this, they're criminalized, and so is there some sort of transition-y plan in there for them to give them that opportunity to possibly turn things around a bit and, I don't know, go to university, or because they've still got that time, they're not 40 years down the track. Because they haven't been in there that long, but they still have been influenced because they were still the 10 and 14-year-olds who missed out on that reform.
Yes, no, I understand. Again, two quick answers to that. One is the overall justice reinvestment agenda needs to speak to, frankly, everybody above 14.
Right.
You know, I'm not giving up on the people who are 40 who've spent most of their adult lives in jail. So we've got things to do with that crowd. So it's about the different cohorts and thinking about it. specifically in terms of the young people, the intensive therapeutic orders, which I spoke about before, will be available to all young people under 18.
Right.
They currently don't have access to that. That reform will apply to all young people. So could take your example, someone who's 17 now and has had a few years in the system, suddenly might get a intensive therapeutic order rather than going to the Youth Justice Centre. Yes.
Cool. Awesome. Thank you.
Welcome. Good question.
Yeah, great question. Thank you, Megan. Thank you, Minister, for your time on a Saturday with the 50 or so people we have online here who are in the middle of their intensive school period, moving from these plenaries into their subject-specific intensives. We appreciate your time and thank you again. We will have a break now until 11:30 and the Australian Human Rights Commissioner, Lorraine Finlay, is on the line, so all's looking good for our next and final presentation, or a presentation on a different law reform issue of monitoring places of detention and OPCAT. So thank you again, Minister, and thank you everyone for your questions. I'll see you at 11:30.